Good afternoon, everybody. Welcome to the afternoon session of the Portland City Council. It's August 9th, 2017. Carla, please call the roll.
Saltzman.
Thanks, Mustafa.
Udaly.
Here.
Fritz.
Here.
Fish.
Here.
Wheeler.
Here. I won't read the whole statement. I think most people here know the drill. We want to create an environment where people feel safe, welcome, and respected as they give public testimony. People here want to hear the City Council's deliberations on the matters before us today, so we're asking everybody to work with us to maintain decorum and order in the council chamber. As per council rules, disruptions are not allowed. If anybody disrupts, you'll be asked to leave. If you don't leave, you're subject to arrest for trespassing. We don't want that to happen. We want everybody to be heard today. Please be respectful of people testifying. If you are testifying, you need only state your name for the record. We don't need your address. If you're a lobbyist, we need to know that. If you're here representing an organization, that would be helpful to know as well. We try not to verbally express either support or disappointment for what's being said, so a simple thumbs up or simple thumbs down helps us keep things moving. So that is that. We have three ordinances that are before us. Carla, could you read all three together, please?
892, adopt new post-deadly force procedures for Police Bureau and authorize legal proceedings to determine validity. 893, approving amendments to settlement agreement between the United States and the City of Portland in United States District Court Case Number 312 CV 02265 SI and Plan for Portland Commission on Community Engaged Policing. And 894, amend Independent Police Review Code to revise filing process, investigation, and appeal provisions of complaints of police officer misconduct.
Colleagues, and to those gathered here, we're opening this meeting with amendments to the DOJ settlement agreement. This came to the council last week as first readings of three proposed ordinance. The item that's gotten the most attention and to which most of the testimony was related to the community engagement piece of these ordinances. I believe we've put together a framework for an effective and credible engagement body. I also believe that it can be significantly improved. As I said, the council heard testimony last week. That testimony, in my opinion, contains some really excellent ideas. I said at the beginning of those first readings that nobody on this city council had come to a final conclusion. I said that we were here to listen to the community and solicit feedback. I want you to know that I heard you and that my colleagues have heard you. And this is the legislative process, and this is how it is supposed to work. So thank you to everybody who took the time to come in and testify last week. Over the next 2 weeks, with regard to the portion relating to public engagement, my office will compile the information that we have collected, both the oral testimony from last week and the written testimony which we've been collecting. We'll write amendments to the proposal. We'll give the public time to review those amendments to the proposal, and then they'll be brought back to the council for a vote. I think there's more we can do, particularly around the issues of policy review. There's improvements that can be made. There's more that can be done around public meetings and assessment of the DOJ settlement agreement. And again, I appreciate the perspectives and the ideas that were brought forward. I think we can make the body's work accessible to Judge Simon. And I think we can secure professional independent services to ensure that the board has the training and support to effect true institutional change. I want to thank those who testified, but I also want to thank the many people who sent written testimony to my office. I want to thank Commissioner Fritz, who spent many, many hours going through and being thoughtful about reviewing these proposals and spending a lot of time over the weekend and working with our team on these issues. I look forward to working with my colleagues and the community over the next 2 weeks. I'd like 1 week to put all of the amendments together and get them out to the public. And in week 2, we'll allow for public review. I can tell you today that we have a time-certain slot reserved at 2 p.m. on August 24th for public review of the amendments that we will attempt to get up at least a week prior to that time-certain 2 p.m. on August 24th here in Portland City Council chambers. I'd like to say one more thing on this issue of public engagement. The COAB faced many challenges, and I believe that the successor, especially the final product, will address many of the challenges that were raised by COAB members head-on. But while the COAB had its ups and downs, it had many successes upon which we can build. Those who participated in the COAB put their time, their effort, and their commitment into the COAB. They owned a process and a body even when they didn't receive the support they should have from the city and other players. The COAB produced a lot of work. I have here in my hand the recommendations of the COAB. My staff has reviewed all of them. I have reviewed them. There are many excellent ideas contained amongst these recommendations around mental health, the use of force, bias-free policing, and other areas. There's a lot of good ideas in here, and I'm going to identify areas of the agreement where we can make the changes and implement the recommendations and do so quickly. I want to thank you for your hard work on the COAB. With regard to the 48-hour rule, Commissioner Nick Fish and I will offer an amendment to honor the intent of the most recent police contract. This will end the 48-hour rule and allow the city to interview officers involved in use of deadly force within 48 hours of the incident. And unlike the current version, we'll implement the policy now rather than waiting until a court gives us the okay to do so. There is risk associated with this strategy, and that risk was clearly laid out by the district attorney and others. But I believe that the principle of eliminating the 48-hour rule, an element of a recent police contract which was hard fought and hard won by this city council, is worth the risk, and that we stand on strong legal ground to begin with. With regard to IPR, the final portion, there was broad agreement on that issue and will go forward today. So here is the run of show. I will ask Commissioner Fish in a moment to please introduce his hard work. I want to thank you, Commissioner Fish, for your hard work and collaboration on this issue in recent days. I think it's been great to work with your team on this, and I want to thank you for your leadership in particular. We will take testimony on the proposed amendment around the 48-hour rule. So those of you who are interested will have that opportunity. With regard to the community engagement piece, I will keep the written record open. There will be an opportunity for public testimony, and as I say, we will post the proposed amendments in about a week, and on August 24th at 2 p.m. we will take testimony. We will obviously take written testimony between now and then, and I would encourage communication on that written testimony. With regard to the ordinance around IPR, it is my intent that we take the vote on that today. So that is where we are. Commissioner Fish, I'll turn it over to you for an amendment on the 48-hour rule portion of the settlement agreement.
Thank you very much, Mayor Wheeler. And I will turn my switch on before I'm admonished by you-know-who. Mayor, I do offer the substitute ordinance 892, and I ask if there's a second, and then I have an opening statement.
Second.
Thank you, Commissioner Fritz. I am very pleased to co-sponsor this substitute with Mayor Wheeler. As the mayor indicated, last year we negotiated a contract with the Portland Police Association that included the removal of the so-called 48-hour rule. As a result, the city is no longer required to give 48 hours notice before compelling an interview of an officer involved in a deadly use of force. In March of this year, the district attorney weighed in, expressing concerns about whether compelled administrative interviews could jeopardize a parallel criminal investigation and possible indictment. The city continues to believe that a firewall can be placed between an administrative and a criminal investigation, consistent with the practice in every other state in this country. Originally, the mayor drafted a new policy that reaffirmed our right to compel interviews, but out of an abundance of caution proposed that we not implement it until the underlying legal question was answered by a court. Based on the testimony last week and our review of legal memoranda and a follow-up briefing with the city attorney, the mayor and I have concluded that our right to compel is supported by the Oregon Constitution and the great weight of case law, and that any risk to a parallel criminal investigation is small. Here is some context. Since 2010, there have been 32 officer-involved shootings, 20 of them fatal. And during that period of time, a single indictment in 2011. That said, to protect against an instance where an indictment seems likely, we have given the police commissioner, in consultation with the police chief and the city attorney, the discretion to defer an interview until such time as he or she deems it appropriate. Now, in 2 weeks, the new policy, Directive 1010.10, will be brought forward for approval. It will continue to require investigations into all cases involving deadly use of force, affirm our right to compel interviews within 48 hours, establish a strong and constitutional firewall between our internal review and the district attorney's investigation, and protect the constitutional rights of our employees. That directive will be brought forward in 2 weeks at the time certain that the mayor alluded to, and it is getting polished, and we want to bring it forward in its final form. Today, we propose to reaffirm our right to compel statements, to provide the police commissioner, in consultation with the police chief and the city attorney, the discretion to delay an interview if necessary, and most importantly, to preserve our right as an employer to investigate and discipline when necessary. The underlying reform was hard-fought and one that the community demanded for a long time. And the mayor and I believe that today's action is faithful to the Constitution and to basic fairness. And we want to be crystal clear. We are not picking a fight with the district attorney. Reasonable people can disagree on this question. I want to join the mayor in thanking Tracy Reeve and the city attorney and all the lawyers for the assistance they've given us in a short period of time on this important set of questions. We want to thank the American Civil Liberties Union, Oregon chapter, for their guidance. I want to thank the National Lawyers Guild, and in particular, I'll refer to the August 2nd memorandum, which was submitted, which provides a comprehensive review of the current case law and has a risk assessment. And we want to thank all the community members who took their time to come and testify and give us their input. And finally, I want to thank Mayor Ted Wheeler, my colleague, for his deep and ongoing commitment to police reform and accountability. I also want to give a shout out to Amira Streeter, who's on my team. And in my 9 years, I can finally say in a meeting, if it's something that I can't grasp, please talk to my lawyer. So with that, Mayor, I turn it back to you.
Commissioner Fish, thank you. Colleagues, just to make sure I have my house cleaning in order, I would ask the city attorney, we now have a substitute ordinance on the table. Commissioner Fish has moved, Commissioner Fritz has seconded. Do we need to take a formal vote to put the substitute into play?
Yes, and then you can take testimony after that.
Very good.
Yeah.
Colleagues,
Can I
any
ask
further?
A scheduling question?
Yes, please.
So, yeah, I'm planning to be on vacation August 27th and 28th. So there will not be a vote on this matter on those dates, I
I believe
presume.
it was, so the.
August 24th.
The
It's-
24th.
You're gone, you and Commissioner Fish are both gone on the 24th.
So I'm actually reversed that vacation day. So I will be here on the 24th.
Okay.
I was talking about the following week, though,
So.
in terms of
uh,
a second reading and vote.
The following week would be a second reading. That's correct, in a vote.
So I'm scheduled to be on vacation. I guess I would ask out of deference
I mean,
that
we-
that vote be put over till the first week of September.
Commissioner, could you call in, or,
It's a vote only.
To vote only?
yeah?
Yeah. Okay.
Why
Well,
why don't we do
Although
this?
I guess, my experience so far has been, sometimes we think we're doing vote onlys and, like today, and here we
Yeah,
are.
no,
sort of,
I
yeah.
respect that. So
So I would ask
let's,
that it be set over to the first week of September.
let's do this. We don't have, do we have to set it over to a time certain today? I guess I'm looking at legal counsel.
Okay, so I apologize, because I was not here for the last hearing. You first asked me questions about the substitute ordinance, which is an emergency ordinance, but now you're talking about a different ordinance?
Now we're talking about what would be, yes, because the only one that will be moved over is the public engagement ordinance. So that would be ordinance number 893.
Okay,
So that piece, we are withholding so that we can put together some amendments.
and so the question is, do you need a date and time certain for when you're going to set that over to?
Yeah, so my assumption is we'll need 2 weeks in order to give people ample time to read the amendments we want to put on the table, and there's some outreach we need to do with regard to drafting those
Yes.
amendments. We'd like to have them public for at least a week so that the public has an opportunity to weigh in on those amendments. On the 24th, it would be my assumption that we would take testimony on the amendments. We could introduce at the end of that testimony, if there's broad agreement, an emergency, clause and vote there. Or alternatively, Commissioner Saltzman is saying if we go through the usual process and the second reading is a week later, he will not be able to participate. So the question is, could we move it 2 weeks to
Yes.
give him the opportunity to vote on that?
Yes. You
Okay.
could, at the 24th, after you take testimony, instead of moving it immediately second reading, set it for a date further out and just announce when that date and time certain is. Or the date doesn't need to be a time certain
Okay,
to take the
and
final vote.
am I correct that we need to do that today? We need to ascertain those dates today?
If you want to, I'm sorry, Mayor. Tracy Reeves, City Attorney. If you want to continue it today and not renotice the hearing, you need to have a date certain you're continuing it to. You can pick a date certain that you're continuing it to and further continue it after that time. Alternatively, it can be renoticed for a new date. But if it's going to be a continued matter, it needs to have a date that it's being continued to.
All right, well, let's do this rather than continuing to confuse everybody. Our office will work with my fellow commissioners' offices. We will renotice it on the city's webpage, and we will endeavor to get the word out to the news media and other outlets. But assume for right now that there will be public testimony on the public engagement piece at 2 p.m. on August 24th as the first step.
Thank you.
And within 1 week, we will get those amendments up on our website and out to the press so that people have an opportunity to digest them. And then what is up in the air is when we will take the final vote.
So, Mayor, you can just continue the matter to August 24th at 2 p.m., and then it will be determined after
Good.
that.
So,
what the vote
and that is the house cleaning we need to do right
Okay.
now. So
Mayor?
without
Thank you.
Commissioner Fish.
So, thank you. There's a lot of stuff before us. Thank you for clarifying what we're doing, what we're not doing, and the run of show. And since we're about to take a vote on placing the substitute on the table before we take testimony, again, I just want to be very clear what the net effect of voting today on the final vote on this substitute, which does have an emergency clause, is that we will be affirming that the version of Directive 1010.10, which was previously in effect, will continue until we bring the revised version of Directive 1010.10 forward. And so we'll be maintaining the status quo that existed last year after we negotiated the changes in the police contract for the 2 or 3 weeks before we adopt this new directive. And we would have had the directive today, except it was the consensus view, it needed a little more polishing, and so we want to get it right. But this effectively puts us back to status quo ante and continues the policy that was in effect before the district attorney opined about his concerns. So that's the net effect of adopting the emergency day, and it is a bridge until the new directive comes forward.
All right, so to remind everybody where we were in the house cleaning process, we now have a substitute amendment on the table. We're taking a vote now to accept the substitute amendment in exchange for what was there previously. Please call the roll.
Saltzman,
Aye.
Udaley,
Aye.
Fritz.
I know this is all very confusing. This vote is just to put the substitute on the table as described by Commissioner Fish. Aye.
Wheeler.
Aye, so the substitute amendment.
I'm sorry, I missed.
What about Fish?
We forgot somebody.
Fish,
Aye.
Wheeler.
Aye. The substitute amendment is now in place of what was there previously, and in a moment, we will take testimony on that item. The next piece of house cleaning is formally, I would like to continue Ordinance 893, which relates to the public engagement part of the settlement agreement, to August 24th at 2 p.m. Seeing a head nod from legal counsel. And after our discussion and potential vote on 892, we'll take up 894. So without further ado, unless my colleagues have anything further to say with regard to Ordinance 892 pertaining to the 48-hour rule, we'll open it up for public testimony. Could I see a show of hands in terms of how many people would like to testify on this issue? It looks like we have plenty of time for 3-minute testimony. 2.5 minutes in the yellow light will go off. 3 minutes in the red light goes on. Please just state your name for the record. And if you'd like to sign up, please sign up with Carla over here. And you can read the first 3 names, please.
Are Lindsay Burrows, Joanne Hardesty, and Dan Handelman.
Very good. Thank you.
Mayor, if there's questions that come up, we'll take them down. We'll have the city attorney come up and answer.
Good. And colleagues, as questions are raised, we'll be taking down those questions, and then at the end of this, we'll have the city attorney come up and work with us to answer those questions.
Thank you.
Hi, I'm
afternoon.
Lindsay Burrows. I'm testifying on behalf of the Portland chapter of the National Lawyers Guild, and my preferred pronouns are she, her, hers. The NLG thanks the mayor and the city council for listening to the public at last Thursday's hearing and taking action in that direction. The NLG is pleased that the city is postponing its amendments to the settlement agreement for further analysis, and the NLG believes that the latest proposed amended ordinance is insufficient to meet the minimum demands made by the AMA Coalition and other community organizations and members. The NLG believes that the amended compelled testimony ordinance before you today is an improvement over the former version. The amended compelled testimony ordinance could present good policy if, one, if it changed the within 48 hours language to by the end of the shift, or at least within 24 hours, and two, remove the exception stated in paragraph 21. That exception, which gives the city discretion to defer an administrative investigation until after a criminal investigation in any circumstances it deems warranted, is overbroad and vague. It creates an exception so wide that it will swallow the rule. We make policy in neutral settings like these, where the public has a chance to weigh in, outside the pressures of an actual use of force incident, so that when incidents do arise, actors can follow the clearly thought out rules and procedures put in place without having to make emotionally charged decisions that have lasting effects and greatly impact community trust. The exception provides no guidance regarding when and how the city will determine whether, quote, the circumstances suggest a deferral is warranted, end quote. It vests with a few people the discretion to decide when to pursue an administrative investigation, thereby subjecting those people to outside influence and pressure, which undermines the ultimate policy.
It's insufficient for the city to tell this community, just trust us. The exception minimizes police accountability by threatening to undo the compelled testimony mandate when it is most necessary in the confusing situations. Instances where the chief of police or police commissioner would feel the need to use the exception are likely the same instances where the administrative investigation is most important. As such, the exception unacceptably fails to address community concerns. Moreover, the amended compelled testimony ordinance no longer mandates, as I understand, the city to seek judicial review of the deadly force directive. The NLG is uncertain why that change was made and believes it does not serve the interest of finality on the issue. To clarify, we think that the 48-hour rule substitute should go into effect immediately, but also seek a court ruling in the interim.
Can I address that one point?
Certainly.
And I have an annotated version of the legal memo that you submitted, and I'll tell you what the intent was, and we can either resolve it today, or we could certainly resolve it by the time the new guidance comes back to council in 2 weeks. We're just talking about a bridge here. There's a reference in your legal memoranda that a court may be reluctant to issue an advisory opinion, and that may not be the most. We cannot compel a court to give us, in effect, an advisory opinion. And so we may not be sort of the masters of the process about how it gets to a ruling. And I think the intent, at least from my point of view, was to set community expectations at a certain level so that, obviously we would like to have a ruling at some point. We'd all sleep better. But we didn't want to mandate some kind of process to get that ruling. It could come up if an indictment is collaterally challenged. It could come up in a number of different ways. And as you've noted, the one wild card is a court may be reluctant just to offer an advisory view on it. We've reviewed the cases. We've reviewed the Constitution. We think we're on solid footing. We're not saying we don't want to at some point have a ruling. We're just decoupling the requirement from this process because we're not sure how we're going to get that ruling. So that was the intent. And if you have language that you'd like to propose over the next couple of weeks, obviously I want to sit down and go over it with you.
That's great, yeah, and the point on the court ruling piece is just reading paragraph 21. I mean, I understand and I completely agree that the city believes it's on strong legal footing. I certainly believe that. But paragraph 21 doesn't indicate that that's how the city really feels, if it's going to create this sort of discretionary thing. So I'm saying if there's worry about the constitutionality, let a court decide, get rid of paragraph 21.
Okay.
Yeah,
And I'm quite confident over the next couple of weeks we can have that conversation. So thank you.
thank you.
So Commissioner Fish, just to be clear so you understand my intent and it's on the record, I believe absolutely we would seek that judicial clarity.
Great. That
Thank you.
resolves
So
that
we
concern.
will
Very good.
harmonize the language.
But what Commissioner Fish is saying is also accurate. We can't make him do it, but we should absolutely seek it.
Yes, I agree. And in the interim, remove paragraph 21 and we'll all be on the same page.
Yeah, with regard to paragraph 21, just so my colleagues know, I'm ambivalent. That's not one I'm going to fall on my sword for. I think we've all heard the risk that is there. And my only ask here on August 9th of 2017 is if we get 5 or 6 years down the road and there's a bad shooting and a judge somewhere throws out a case because he agrees with the political opinion of the district attorney and the attorney general, you'll be standing with us at that time and saying we were there and we agreed the risk was worth taking in order to support the principle of eliminating the 48-hour rule per the agreement we have with the union. Just to be clear.
Yes.
Excellent.
Can I
Thank
just
you.
make one?
Commissioner Fish.
The mayor, if I could just modify one thing, Ted, you just said. If it's the legal opinion of the DA, not the political opinion. We recognize that as the district attorney interpreting the law, there are going to be occasions where we have a disagreement. But that disagreement does not prevent us today from confidently moving forward with the policy that we negotiated with the Police Association last year.
Right on.
So good.
Points of clarification for us non-lawyers. Which paragraph 21? I don't seem to have a paragraph.
I'm thinking about paragraph 21 in the draft, yeah, in the resolution.
Okay,
So
thank you. I'll
just on the
Find that.
page
Under 21?
3, the very last
3 or 4?
paragraph.
Thank you.
Thank you.
May I?
Please.
Good afternoon. For the record, I am Joanne Hardesty, and this initial statement will be read on behalf of the Albina Ministerial Alliance Coalition for Justice and Police Reform. The AMA Coalition for Justice and Police Reform calls on the City of Portland to modify its amendment plan regarding compelling testimony in deadly force incidents. The AMAC commends Mayor Wheeler and Commissioner Fish for putting forth an amendment requiring immediate implementation of a directive that mandates prompt, compelled testimony from police officers who use deadly force. I guess I should have paused when I said we commend you, just so that you could have that sink in. They
I
said
don't
thank
even
you.
know what that means.
Commends, thank you. This was good. You did something
you.
good, is what
Thank
they
you,
said.
Joanne.
Okay, yeah.
Appreciate it.
I figured I should pause, because we normally are beating up on you, so we just want to appreciate that.
Thank you.
It is unclear whether this proposal requires compelled testimony within 48 hours or 24 hours. The AMAC hopes it is the latter for the sake of obtaining an accurate account and reducing the likelihood of collusion. The AMAC is discouraged to see that the revised proposal does not direct the city attorney to seek judicial clarification of the constitutionality of the directive. This is especially concerning because the amended proposal includes a new broad loophole for compelling testimony. Paragraph 21 allows the city to defer an administrative investigation until after the criminal investigation is complete, where circumstances, and this is in quotes, suggest that such deferral is warranted in a particular case. If the city has a particular concern about compelling testimony, it should seek judicial review of the directive or include only a very narrow and specific exception to the rule that testimony should be compelled within 24 hours. A minute and 15 seconds left for the NAACP. I want to, using my NAACP hat, also commend you for really hearing clearly from the community last week. It is wonderful to finally get from the City Council chambers an acknowledgement of the incredibly hard work that Community Oversight Advisory Board members did. I am so proud, Mayor, that you actually have their recommendations, and I'm even equally proud that you read them and plan to do something with them. This is the first time in my memory that anyone from this podium has said anything good about the work of the COAB. So thank you for that. I also want to say, please remember that there's a reason the Department of Justice Civil Rights Division was invited to town. What the Department of Justice suggested at that time, clearly under a different administration, was that after action reports would be written at the end of the shift when a deadly force incident took place. What you are now proposing is instituting the 48-hour rule, even though we paid $10 million for it to go away. And so I would encourage you to go back, review the settlement agreement, the original one, not the one that's been revised, and make sure that what we're doing is making sure that we get a statement as soon as possible, and the community prefers at the end of the shift. There's no reason why police should have more time than the rest of the public. Thank you.
Thank you. And just to underscore a couple of points you made, I mentioned a moment ago that I was ambivalent
Yes.
on this question of paragraph 21. And
Yes.
the reason, I should probably be precise about why I'm ambivalent about it, so people don't think I don't care about it. I care intensely about it because I am mindful of the DA's interpretation. The reason I'm ambivalent is twofold. Number one, I agree with you. I believe we're standing on strong legal grounds, and I've had the opportunity to vet this with a lot of people who have great legal minds. Not me, just to be clear. I am not an attorney. But fortunately, we have access to lots of people who are. And I believe we're standing on strong legal ground. The second one, for my own part, Joanne, I would obviously use that exception extremely judiciously. But I'm also realistic, and I understand that politicians saying, trust me with this tool, doesn't carry a lot of weight
Right.
in today's society. It's too bad that it doesn't, because the truth is I was elected to use good judgment, and ultimately I can be held accountable by the public in my exercise of that judgment, either good or bad. But I understand that what I'm setting here isn't a policy that comes and goes in a couple of years. I'm attempting to lay down a foundation that many mayors and many city councils will abide by in the years ahead. And so I understand that for many people, asking for that opportunity to judiciously use that tool may be going too far. So that, when I say I'm ambivalent, I just want to be clear. I don't mean I don't care. I'm weighing these competing interests, and at the end of the day, I believe we're standing on strong legal ground.
Thank
So,
you, Mayor. If I could respond just very briefly.
you bet.
I think the challenge is that you are advised by the same attorneys that advise the police officers, and so there is no way they're going to give you advice that is in conflict with the advice they're giving to those same police officers. So the fact that you have the same attorney does not make this exception work better.
Well, in this case, I think you'll find the attorney is actually very clearly in support of, what we're discussing here is a legal framework. But I get your point.
But you do understand
And
that.
I do reach out beyond just who is here in the room.
But it's really
So, you know.
important that the council really understands that if the police union is seeking advice and the mayor is seeking advice, they're seeking advice from the same attorneys.
Sure.
Right?
Sure.
So you're not going to get different advice based on whether there are police involved or not.
Well, I'll let the attorney defend the work of her office.
No
later.
need, no need.
Very good.
Thank you.
Mr. Handelman, thank you for coming in.
I apologize, I have to leave for a meeting.
No worries.
Thank you.
See you later.
Hi, again, City Council members. I'm Dan Handelman from Portland Cop Watch. And I had to scramble to rearrange the testimony I was going to give today because I read the draft substitute that was put out on Monday, and then another one was put out yesterday that I only just read before the hearing. It was my understanding that what you were going to do was implement the rewritten policy that we saw last week right away, and that seems to be taken off the table in favor of writing yet another version of the directive that's supposed to be happening in conjunction with the DOJ over the next week or two, right? That's
So there's a reason for that, Dan.
I understand, Commissioner Fish. I just want to make sure I understand what is happening.
We are, and it's because, quite frankly, that directive was not ready for prime time, and because that directive was not going to be put into effect for a year or two, or to whenever the judicial process ended, it had not been vetted, in my judgment, for prime time. So what we've done is we've said, let's make sure it's the final version and that we've dotted our I's and crossed our T's. I don't think you're going to see, I hesitate to say this, Dan, but I don't think you're going to have substantive objections with the final version. And if you do, we will sit down and talk about it.
Okay, I appreciate that, Commissioner Fish. But as one of my colleagues has already, or both my colleagues have already said, what it already says is that the compelled testimony should happen within 48 hours, and Portland Cop Watch joins our colleagues in saying that it should say the compelled testimony should happen as soon as possible, and if necessary, no later in any circumstance than 48 hours, except that the paragraph 21 should list specific reasons you might exempt the compelled testimony. The only one we can think of that's a good reason is if the officer is incapacitated, right? Because obviously you don't want to try to get them to talk from their hospital bed if they can't speak. So other than that, we can't think of a good reason why you would delay it, since we all believe the legal standing is there for you to compel the testimony. The current directive that's in place is silent on what Internal Affairs does, and I should have brought our testimony about how things changed between that version and the version that the Bureau was going to implement until this is going to take the Bureau's revised version off the table, which we submitted in November of 2015 and then again in early July. I'd also like to point out that we could have had this conversation before we got to this point if, as soon as the policy that's currently in place actually got changed without any written notice, because, as was testified to last time, the officer who shot Terrell Johnson wasn't interviewed for 6 weeks after that shooting. So that means the current policy allows, unless I'm wrong, allows for them to wait 6 weeks to interview. So let's hope there's not another shooting in the next 2 weeks before you adopt the new policy. And just in terms of the changes that are being made so rapidly, it's like we're on a merry-go-round where you all know where it's going, you can get off, and the community's getting thrown off the side because we don't know when it's going to stop. So it's really hard to follow all of this because there's so many
I'd like to
changes.
interrupt. I'm glad it seems that way because I think
Yeah, that's not the
there's
case.
a lot
You
of
feel
things
that way
moving
too,
on our
okay.
end too. And it's because we're trying to respond to testimony.
Well, we're very appreciative, again, of what Joanne said about the community's impact on this. But we could have had the discussion a lot earlier because people knew that this policy change had happened.
So Dan, can I ask you a question?
Yes,
In the original ordinance,
yes.
the one that was filed last week, in the therefore clause, sub B, it says the city attorney's office is authorized to file legal proceedings if appropriate and/or join any appropriate parties or intervene in any legal actions, blah, 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 to determine the validity of this policy. Just to both you and the National Lawyers Guild, is that the paragraph you'd like inserted back in?
Sure, I mean, and I think our point is that it's unnecessary and maybe not even possible, as you indicated, to get a judicial ruling, but if there is still concern that's leading to paragraph 21 being in there, then the way to deal with it is through seeking the court ruling, not in adding this discretionary piece.
So the one thing I would ask both of you is if you would take a look at that language between now and the 24th, and if you have any wordsmithing of it, let me know, because I see no harm in putting that back in, but I want to make sure it's written in a way that you think gets it at what you've testified to.
Oh, I appreciate that too, Commissioner Fish, but I don't see the reason why to put it as an option for the city attorney. Why don't you just give the attorney the directive, as the original ordinance said, to go to the court and ask for a ruling? If the court says, no, we're not going to rule on it, well, whatever, then we're back in the same place, but at least you've tried.
I just read from the original ordinance.
Oh, no, you were reading from the one that came out on Monday, because I think, unless I'm mistaken.
Well, we can,
Okay.
Well, this is fun, but.
Okay. My understanding, the original one was it directed the city attorney to file that.
we'll ask the city attorney when she comes up.
Okay, thank you. So my last couple points are, we know one of the parties that's going to be very concerned about this is the Portland Police Association. I don't see them here in the chambers today. Their concerns, when they are brought up, very rarely happen in this room, and we're tired of that. We want to see them here and expressing their concerns so they can, with the community, we can have a dialogue about how we can all move forward together. And just as another point, there's been no indictment on a death since 1969 of a Portland police officer. Last point about the PCCEP, glad you're taking it off the table for now. Our main point that we didn't get to in the oral testimony a couple weeks ago is that this is for beyond the life of the DOJ agreement. So therefore, to make sure that the elements of the DOJ agreement stay in place into the future, they should be able to look at whether the implementation is happening. So please don't take that away from them.
Yeah, we have heard that loudly and clearly, and we are drafting an amendment in order to honor that exact belief.
Thank you, Dan.
And we're in agreement. Commissioner Fish, could I ask you one question?
Yep.
So the substitute ordinance is an emergency ordinance. Is it your proposal that we would potentially vote on that today or no?
Yes, precisely because of what Dan Handelman just testified to, we want to make sure that we're operating in the landscape that predates the district attorney's opinion and any changes in policy. You and I have agreed, we want to go to status quo ante, restore the policy that was in effect after we negotiated the police contract and before the district attorney's opinion. And when we bring back the revised Directive 10-10-10, it's my intention to offer an amendment
okay.
that would
That's
provide,
what
that would
raised the
direct the city
confusion.
attorney to seek a legal review of that, but we
Good.
have to have that policy adopted before we can seek.
I
review.
agree wholeheartedly, and thank you for that clarification. That was my expectation. Next three, please.
Okay, good.
Next three are Barbara Boshinsky, Edith Gillis, and Shedrick J. Wilkins.
Coming up. Good afternoon.
Good afternoon. My name's Barbara Boshinsky with Copwatch, and I was going to get taken off, but I just want to say I agree with Joanne Hardesty and Dan Handelman. And I am also concerned because I don't feel that police departments in general are, maybe the city council is, but I have a mistrust of the police departments because when Trump made that joke about hitting the heads of prisoners, the police laughed, and police chiefs were saying, oh, no, that's not what we do. But I didn't hear, my understanding is that none of the police unions have really come out against that. And I think that there's some level of thinking that some of these behaviors are just okay, so that I think it's really important to have a strong wording, and I'm not a lawyer at all, and a strong wording so that they can't then sympathize with some police officer who's upset, understandably, about what he did, but then make it okay because he's upset and they know him, you know. So I would like a clear statement.
Very good. Thank you. We appreciate that. Good afternoon.
Hello, my name is Edith Gillis, and I'm back to paragraph 21, page 3 at the bottom. I want us to compel testimony within 8 hours of the incident, and I want us to have that recorded and available. I want to make sure that we specify under what conditions it would not happen, and that is to be specified as the officer is incapacitated, unable to hear or read, sign, speak, or write. I want to have all the other witnesses and participants, and whether they're city employees or not, who are as contractors or employees of the city, to be compelled within that time period also. I want to make sure that all the evidence is secured. Over and over, Portland Police Bureau employees plant weapons at the scene and say, oh, it was found, that's an excuse. No. That is a crime. We need to prosecute it as it never has been.
Thank you. Good afternoon.
Yeah, my feeling about the police, and I rarely want to comment about this stuff, is police should not rule by intimidation. I support Mimi Gurman and Starr's proposal of cutting ammunition practice. When you're in a practice range, the target doesn't move. In real life, they move around, evade a bullet. So, I don't think you're learning much by, obviously you feel uncomfortable with a gun. You don't need to do this all the time. I really support the new hiring of a woman African-American police chief in October. This is really great. I thought I was dreaming last night when I heard about it. this is good because you might see some sort of sensitivity about what people feel about the police. And also to, I believe, ultimately, police not ruled by intimidation, but I do believe that we should stop calling emergency response teams searching. Just call it what it is. It's a SWAT team. And the purpose of a SWAT team is to make sure some guy buys a bunch of automatic rifles and thinks he's going to shoot up the place, is not going to survive 10 telescopic guys with rifles. And it's going to end right there. You either turn yourself in or it's it. Okay? It's a SWAT. It's like swatting a fly. Stop calling it something else. The police are swatting you. And, having these kind of guns puts ideas into people's heads. And that's the way it must be. And again, I do not believe police should rule by intimidation. I don't think we should have mounted police on a horse. And I don't think we need to have target practice all the time.
Thank you. Next three, please.
That's all who signed up.
Very good. So colleagues, why don't we invite Tracy back up to the front of the room? You've heard the testimony we've had today. Commissioner
Do you mind
Fish?
if I?
Not at all.
So, Tracy, I've heard three arguments through the testimony. One is that we should include the directive about your office filing legal proceedings and the like, which was in the July 21st draft of the ordinance. Dan is right, so go back to that one. That we should include that in any final document. That's the judicial review piece. Two, that we should put sideboards on this exception that's been carved out under paragraph 21, so it's clear that it will not be abused. And 3, a question about whether a compelled interview should occur earlier than 48 hours or 24 hours or prescribing a particular time frame. Those are, Mr. Handelman also said in his testimony that this feels a little rushed. There's a lot of moving pieces. Amen to that. The goal was by today to have an ordinance that says we're back to where we were last year, and then finalize the directive. In a perfect world, we do it slightly differently, but I think the intent is right. The intent is to put in place our pre-existing policy. Those 3 issues, judicial review, the time frame for the interview, and sideboards on paragraph 21, those are all important issues to me and to the mayor. We've done a lot of work to get to today. My question to you is, the mayor has said he wants to file amendments next week that people can review and then come back the following week. Could we, over the next week, come up with amendments that address these 3 issues, have them as part of the mayor's package, and then bring that back on the 24th?
So we could include, if you provide staff direction today, we could certainly include in what the current plan as this is contemplated is that a policy substantially similar to what people saw. And I'd just like to clarify a bit. Under the Department of Justice Settlement Agreement, there's 48 essential policies that before we implement, we're supposed to negotiate with the Department of Justice and their police practices experts to ensure that we're implementing best practices. Because, as Commissioner Fish noted, the 10-10-10 that is not now going into effect, but that was negotiated to recognize the district attorney's concerns, had gone through that process. It was intended to take effect simultaneously with a new 10-10 policy that has been fully vetted that improves the Police Bureau's use of force policies. Right now, we're going to have a period of time where the use of force policy is not synced up with the new investigation of uses of deadly force because we're making improvements and responding to community concerns. So I guess my concern is that we not extend that period of time anymore. We need to where we have less than cohesion between the Police Bureau policies. Department of Justice is working on and making some I would say non-substantive suggestions to what we're working on. So I think it will be very similar to what people saw. In terms of the directive, it will not be to wait 48 hours. It will be that the interview should be compelled as promptly as possible. It just defines the outside edge of that as 48 hours. But there's no reason that those interviews can't occur within 24 hours where that's possible.
Okay.
In terms of the exception, allowing some kind of a discretionary exception in particular circumstances, I'll be honest, that is intended to get to situations, and many jurisdictions do this. Seattle, after their whole Department of Justice policy, has a policy that does this. They do an initial, very kind of gut check evaluation of whether a shooting looks like it's likely to be, put colloquially, a bad shooting, because that's the shooting that has a chance of meriting a criminal prosecution. In those circumstances, Seattle does not compel a statement. It defers to the criminal investigation. So there's a number of jurisdictions that have policies of regularly compelling statements, but have a situation, and I'll give an example. We had the shooting, luckily it did not result in a death, but it was nonetheless a tragic situation where we knew right away that the officer had intended to use beanbags and actually shot someone with live ammunition. In a situation like that, that might be a situation where you say, hey, this looks like there is potentially criminally negligent behavior here. And in that situation, the police chief and the police commissioner are going to make a determination. We do not want to risk immunizing an officer. For what we look at, we take an initial look and say, there's a possibility, a significant possibility at first examination that this is potentially criminal behavior, and because there is a significant risk, we think the better view of the law is that you can wall it off, but there is nonetheless a significant risk of immunizing potentially criminal behavior. So that's the intention. That's ultimately a policy call for the council, but I will tell you that many jurisdictions with 21st century policing policies do have that kind of an escape hatch.
And then finally, this question about whether you're encouraged to file legal proceedings or directed to, do you have an opinion on that?
I do, and I would prefer that if you're going to add something back in that regard, that you make it that I'm directed to explore doing it. I'll tell you the reason why. There is a statutory provision for a procedure called a validation procedure. That is what we intended to invoke had council gone with the option of, we're going to adopt this policy, but then we want you, city attorney, to go get a court ruling. To use that methodology, the court ruling has to be gotten before the policy goes into effect. It cannot be used to validate a policy that actually takes effect. Any other kind of court proceeding, I think we have a very, very, very high risk.
In that instance, it would be self-defeating if we went that route. So this is, and I'm seeing our friend from the National Lawyers Guild nod. So, Mayor, this is why it's my considered opinion, since we've been working diligently to get to this point, that we take the time over the next week to craft some amendments that are carefully considered with the city attorney's office. And I have learned a lot in the last, 4 days, 2.5 work days. And I'm the lawyer on the council. That doesn't count for much, but I mean, it just means that I look at this through a lawyer's lens, and I'm trying to get it right. And I'm not entirely sure what the right answer is, and there is no reason for us to do the amendments today, because this was only intended to get us to the point in which we had a directive that we could adopt, because it is that directive that will then be subject to challenge. The directive is the actual policy.
Correct. What the ordinance does today, and what I would urge you to consider, is that it directs the police bureau not to implement the 10-10-10 policy that has been approved through the DOJ process that will otherwise take effect on August 21st, and that would not compel interviews until after the criminal investigation. So if your intent is to not have that directive that is slated to go into effect on August 20th.
We have to act on that today.
Yes.
And that to me and the mayor is the most important issue on the table. The question of under what circumstances we direct you to seek a judicial decision, the sideboards, which I hear the concern, I think we should consider how to frame those sideboards. I think those for me, because I've been spending a lot of time on this, would benefit from another week of working with advocates in the city attorney's office to draft the right language. And so that's my suggestion. We adopt this and we bring amendments in 2 weeks.
So could I suggest that we remove paragraph 21 today?
It's of no moment either way.
We've heard from the community they would like that. I do respect when you say there's a significant risk that the criminal investigation could be tainted. However, with only 54 officers having been indicted nationwide since 2004, out of hundreds or tens of thousands of shootings, about 400 a year, that to me doesn't seem like a significant risk, because it just doesn't happen.
But may I be clear on this as someone who's been putting a lot of time into it? All I'm suggesting is we make that decision in 2 weeks. I'm not arguing the merits.
Yeah.
I may very well agree with you. All I'm saying is, I think the 3 issues that are before us are important issues. I think they require thoughtful consideration. I would actually like to talk to my colleagues with the city attorney's office. I'd like to follow up with the National Lawyers Guild and ACLU with language. All I'm saying is, I think we can resolve that in 2 weeks. I would prefer not to vote on that today.
But isn't that part of your substitute that you are asking us to vote on?
No, all we're doing today is essentially saying we're not adopting the revised 1010, and we're going back to the status quo that existed last year following the police negotiations. So we're going back to the position that we started, that we can compel interviews and there's no 48-hour rule. The additional things that have been brought up, I would consider important fine-tuning, but they do not have to be decided today. They can be decided over the next 2 weeks.
If I may, the only operative portion of this ordinance, the portion that Commissioner Fritz is referring to is in one of the findings. It is not in the council directs. The only thing that this ordinance does legally is have the Bureau withdraw the 10-10-10 that would otherwise take effect, have us and the Police Bureau work with the Department of Justice to prepare, and it says right now, file within 1 week, a revised version. That will be a resolution because it will be an internal policy directing council, so that could be amended based on any testimony and still voted upon at the same hearing. And then finally, sub C says, until that occurs, the police will use the 10-10-10 that's currently in effect, that under which they can compel, and it says they shall promptly compel or obtain a voluntary statement.
So that's helpful to me in terms of the resolved is what we're actually directing. The findings, do we need to amend the findings?
No.
No, all right.
No, and I say that only because this has a very narrow purpose that directly responds to the concerns raised by the community. It has been vetted for that narrow purpose, and it may very well be that the council decides to adopt all 3 recommended changes with some wordsmithing, and that would be your privilege to bring those forward, to argue for them. There may even be consensus. All I'm saying is I don't think we do our best work on the fly here on that, and I would just urge that we take the week to come up with amendments and then debate it when we come back for the second hearing.
Thank you, that's much clearer.
And I would strongly support that strategy. There is a timeliness issue, and it's been raised previously with regard to the implementation of 10-10-10. And so it's my personal preference that we move forward on the substitute ordinance today, take that time. Personally, I think it's a tough ask to figure out how to narrow that rule. It gets back to that statement I made earlier. It's really an either or. It's not a refinement of, but if people have good refinements, I'd be very, very happy to listen aggressively to those refinements. And I am very interested in seeking that judicial review. I think we need to have this issue addressed once and for all. I understand exactly what you're saying, Tracy, and I appreciate what you're saying with regard to the availability of that tool depending upon how we handle this situation. So if there is no further discussion on this, I'd like to call the roll on the substitute amendment 892. Substitute ordinance, I'm sorry, 892.
Saltzman?
Well, I want to thank Commissioner Fish and Mayor Wheeler for your work on this. I think it's an improvement. I guess I would want to see judicial review happen in some form or another. I guess, with all due respect to our city attorney, about section 21 or paragraph 21. I am sort of wondering if we need it or not, and I guess I'm leaning towards maybe we don't need it right now, because the exceptions will always sort of drive events, and when the events are in the thick of it, in a shooting, a controversial shooting or something like that, it seems like the benefit always accrues to the officer and not to necessarily to the public's interest. So I think I could live without a Section 21 exemption at this point.
Just to clarify, I think that's completely a policy call for the council.
Okay. So I guess that's where I'm landing right now. I'll wait and see what gets developed in the ensuing weeks. And, yeah, with that, I vote aye.
Udaley?
Well, thank you, Mayor and Commissioner Fish, for taking this on. This was an issue that my office had flagged, and it's always nice to have one less thing on our to-do list. I wanted to take a moment to address something that one of the community members said in regards to recent statements by President Trump. It's not surprising that the public is cynical about the police, given that the largest police union in the country endorsed Trump. The police take a lot of criticism. Some of it is deserved, some of it is undeserved. But I just wanted to point out that police departments across the country spoke out against that statement by Trump that officers should be roughing up suspects that they're arresting, including the department in Suffolk County where that comment was made. Aye.
Fritz.
I also thank Commissioner Fish and the Mayor for their willingness to engage, and thanks also to all the community members who've given such diligent advice and the City Attorney being willing to listen to it. I'm with Commissioner Saltzman that I would prefer not to have an exception. When I was 22 years working at OHSU in psychiatry, I was required to document at the end of every shift what happened. You document in very objective language, and if something went bad, you were also, something untoward happened, you also had to fill out an incident report at the end of the shift. And I don't see why officers should be any different. I'm going to enter into the record an email that I got from Professor Daniel Reisberg at Reed College, who's an expert in psychology and about stressful events. And he's basically saying that, yes, testimony might be better after a few hours to decompress, a day at the most, but otherwise any claim that any longer than that is going to be better is just false. So I think we are getting there on this, on many other things, and I appreciate the collaborative way that the council is working together in one-on-ones, and then we come together and we hash it out in public, which is exactly what should happen. Aye.
Fish.
Yeah, I want to thank everybody who has been working on this. It is complicated stuff. We've done a month's worth of work in about 3 days, but I think we've been clear about what our goal is to go back and affirm a national best practice of ensuring that these interviews occur in a timely manner so that they can aid the city in doing its investigations and potentially determining appropriate discipline, and that we continue to believe that there can be a constitutional firewall which protects the integrity of both the criminal investigation and the administrative review. For those of you who want to do some additional research on this question, for whom this hearing has piqued your curiosity, I would go online and I would urge you to read the National Lawyers Guild legal memoranda, which has about 50 footnotes and has a lot of sections, and it basically walks through the case law, the policy issues, and how they end up landing on this. Everyone's free to reach their own conclusion. I think it's an excellent place to start if you're not familiar with this question. Tracy, thanks to you and your legal team for the advice you gave the mayor and me. Thanks to my team, Amira Streeter, Sonia Schmansky, and others. Mayor, thank you for the relationship with your office. And I want to echo what Commissioner Fritz just said. We've had some very complicated issues come through this council in the last month. And there's this lore out there that all you need is 3 votes to move legislation in this building, and that's fine. I reject that. 3 votes is the minimum requirement for moving something. But what I think we've learned as a body, and I think we've demonstrated in the last 6 months, is that if we take the extra time to engage every single perspective on this council, we get a much better outcome and a more sustainable outcome when we get to 5. Because it is respectful of all the perspectives on this council, not just to what 3 people think on an issue. And I will tell you, while getting to 3 is certainly a path, I view it as more of a shortcut. Getting to 5 takes more work, and it requires more consultations and trust and other things. But I think the more complex issues that this mayor steers to a vote of 5 will ultimately reflect well on his leadership style. So thank you, Ted. Aye.
Wheeler.
Right back at you, Commissioner Fish, and I've enjoyed working on this council. We have some good discussions, we have disagreements, but at the end of the day, everybody up here pulls their weight, puts in their homework, and works hard to come up with the right solutions. I want to thank people in the community who took the time to testify on this. It's been really good and important testimony. This is one of those values conversations that's been disguised as a policy discussion or a legal framework. And I think part of the reason the public was so aggravated by the approach that, and I'll just fess up to this myself, the approach I originally took on this, because frankly, I was looking at the settlement agreement and compliance with the settlement agreement and making sure that we had policies in place that were clear, that were achievable, and would move us towards the stated reforms that I ran on. I think that actually came into conflict with a deeper, more emotional values conversation that we needed to have in this chamber, in which we have had and which we will continue to have around these important issues. So I, for one, thought it was a great exercise. I have to stand it in contrast to a different conversation we had earlier in the day. Getting to real estate, you know, there's a narrative out there that is it not working? Did it bug out again?
They're switching captioners. It'll be a moment.
1 second, 1 moment. People waiting for real estate will be right up in a minute. That captioning thing is interesting. They actually do that manually. Now the captioner fell over and died. He saw me about to speak.
Like a good lawyer, now you can repeat everything just to let it sink in.
How can you tell whether they're there or not?
Sometimes they'll log themselves back up. It looks like they're.
Well, this is just the exact opposite of some of my early council sessions. I thought that was funny.
Looks like they're back.
I'm trying to figure that
All
out.
right, anyway.
You were mid-speech.
I was just going to say, there's a balancing act here. I know to many people this feels like we're moving forward at the speed of light. And in many regards, we are moving very quickly, and there are timeline considerations here that are driving that conversation. So I apologize for that, but it seems like everybody's keeping up and giving us good counsel and feedback on this. So without further ado, the substitute ordinance is adopted. As a reminder, we have moved item number 893. We've continued it to August 24th at 2 p.m. We will continue to keep the record open on that written record, and there will be testimony on the 24th. We will now, we have a second reading of item number 894. If there's no further discussion, I'll call the roll. Please call the roll.
Saltzman?
Aye.
Udaley?
Aye.
Fritz?
This is on the amendments to the Independent Police Review Code, and thanks to the Auditor and Director Sevier for your very diligent work on this. It was good that was universal support for these changes last week. And on that issue, I have found it so helpful to have had respectful hearings where people are certainly still extremely anxious about what should happen and forceful in their comments, but that we haven't had disruptions the last 2 weeks, and that's helped me be able to focus on things that people are saying rather than sometimes where we're in and out a lot. So I hope that that mutual respect continues to go on. Aye.
Fish?
Aye.
Wheeler?
Thank you, everybody. Aye, the ordinance is adopted. We'll take a 3-minute break, and then we'll come back for the hearing. Thank you for those of you waiting for your patience. We appreciate it. Item 895. Thank you all for your patience. We appreciate it. We're about 25 minutes late, and I know people's time is valuable, so I want to thank you for your patience. Please read item 895.
Appeal of Landon Kroll against Design Commissioner's decision of denial for design review of a new 5 to 6 story, approximately 70-foot tall, 17-unit apartment building in the Central East Side Subdistrict of the Central City Plan District at 1122 Southeast Ankeny Street, LU 16-184524DZM.
Colleagues, does anybody have any new ex parte contacts to declare? Nobody has any ex parte contacts to declare. Does anybody have any questions that they need to ask regarding ex parte contacts? Seeing none, I will ask staff to come up to the table to provide an update. While they're doing that, I want to be clear, there is new evidence in the record. Participants will need to be allowed to testify about the new evidence. Typically, what we would do is we would allow 3 minutes per person, or if people feel like they need more than that, if people could let us know. And so, the run of show will be I'll allow the applicant to describe or testify to the new evidence. I'll allow any other participant to testify to the new evidence, and then we will deliberate and hopefully come to a conclusion. And if I got that wrong, I will absolutely be corrected by legal counsel at some point. Good afternoon.
Good afternoon.
Good afternoon, Mayor Wheeler, council members. My name is Grace Jeffries from the Bureau of Development Services. I have a brief presentation for you today, which consists of 6 parts: background information, council feedback from the last hearing, revisions since the last hearing, how the revisions address the council's comments, a staff recommendation, and the alternatives facing the council. So in terms of the background summary, the pre-application conference for this proposal was held on February 16th, 2016, and was followed by the design review application and 5 design commission hearings, and ended in the denial of the application. That decision was then appealed to the City Council, and this is the 4th City Council hearing of that appeal. Through the design review process, the Design Commission found that the proposal did not meet all the applicable approval criteria. Therefore, the request was denied. 7 design guidelines were cited as not being met. These included A4, A5, C2, C3-1, C3-2, C5, 4, and C5. Under their final findings, the Design Commission identified 3 major aspects of the proposal that did not meet the guidelines. These include the massing scale and bulk of the sidewalls, the impact of the open stairwells on adjacent properties, and the quality and permanence of the proposed metal cladding. At the last hearing held on June 21st, 2017, a revised proposal was presented to the council with 4-foot setbacks on the south side, a slightly reduced height for the tower on Southeast 12th, and the addition of wood cladding. The council commented that with the setbacks in the wood siding, the massing on the south side appeared more contextually responsive. However, the council still had several concerns, including the contextual response on the north and east property lines, the impact of noise and light from the open stairwells on adjacent residents, and the impact of construction on adjacent properties, as well as the challenges of ongoing maintenance of cladding on the 0 lot line walls. The appellant has now submitted a further revised design, and as requested, a full set of design review drawings was submitted to BDS staff for review prior to this hearing. This package was forwarded to the council, shared with interested parties, and uploaded to the city's website for public access a couple weeks ago. As recommended by BDS, the appellant also held a preliminary fire and life safety meeting, and the minutes for this meeting are attached to this memo that you have in front of you, hopefully. So this revised design incorporates the changes appellant presented at the 3rd hearing, as well as new revisions added to respond to the council's comments. This includes setbacks on the property lines on the south, north, and east, including 4-foot setback on the south property line with added windows on those elevations, a 3-foot setback along part of the north property line with added windows, and a 1-foot 6-inch setback for the remainder of that property line, as well as a new 3-foot setback along part of the east property line adjacent to the Sturgis property, which is the property immediately to the north of Southeast 12th Avenue lot. It also includes the slight height reduction of the tower on Southeast 12th and the addition of the stained cedar wood siding. As well, there's a new provision of a construction management plan, and like that offered to the neighbors to the south, the neighbor to the north was offered a baseline evaluation of their structure for comparisons of the conditions before, during, and after construction. So how these revisions address the council's previous comments. So the setbacks proposed provide the opportunity for a more contextual response at the sidewalls, and massing changes and added windows help reduce the scale of the tall exposed sidewalls. These setbacks also help address construction and maintenance concerns by allowing construction and maintenance to occur without necessarily imposing on the neighbors' properties. These setbacks would have been welcomed by the Design Commission during the design review process. The stained cedar vertical wood siding will provide a durable, more residential feel for the neighborhood. The construction management plan addresses concerns about the impact of construction on the adjacent neighbors. It illustrates how the construction can occur without imposing on the neighbors' properties, if necessary, and by switching to a less impactful foundation system, addresses concerns about impacts the construction might have on these adjacent structures. As well, the baseline evaluation offered to the immediate neighbors will document existing conditions, as well as help the appellant's contractor develop recommendations for construction protection measures and monitoring, if necessary, to protect the foundations during construction. The appellant advised that the project will follow the reasonable recommendations of the study. And finally, in response to concerns about the open stairwells, several changes were made that flow from the increased setbacks, including moving the elevator shaft and adding open walkways on the upper floors. The stairwells have been placed behind the walkways as viewed from the Sturgis property to address concerns about the impact of lighting and noise from the open stairwells. The extent of these open areas has increased due to the relocation of the elevator shaft. However, these walkways are set back from the property lines by approximately 12 feet. New screening has not been added to the stairwells in order to preserve the passage of natural light between the building segments, which was desired by the adjacent neighbors. So the staff recommendation This site is in the central city and has zoning allowances greater than those allowed directly across the street, which is outside the central city. These allowances allow for larger scale development with potential to have greater impact on the surrounding built environment. With these larger allowances comes a greater responsibility to respond to context. Therefore, a design overlay was added in these higher density areas. This site is also located at the very edge of the Central City Plan District, and additional guidelines were added here to ensure that the transitional nature of the area is considered. These include C3-1, which is designed to enhance existing themes in the district, and C3-2, which is respect adjacent residential neighborhoods. Given the small size of the site, the unusual shape of the lots, and the ambitious programming, from the start, staff had major concerns with how the proposal would meet the design guidelines, as discussed with the appellant at the pre-application conference. With this revised proposal, staff would like to have seen even further breakdown of the massing, which would have in turn allowed for more refinement of the composition. However, the changes that have been made help the design move closer toward meeting the guidelines. Based on these changes, staff feels most of the council's concerns at the last hearing have been addressed, and is now the council's task to make findings on this case. Alternatives facing the council include denying the appeal and upholding the Design Commission's decision to deny the proposal, grant the appeal and overturn the Design Commission's decision to deny the request, thereby approving the appellant's revised proposal, or thirdly, grant the appeal and overturn the Design Commission's decision to deny the request with added conditions of approval and/or further design revisions, thereby approving a revised proposal.
Commissioner Fritz.
So we would have to add more conditions of approval if we wanted to do number 3. Is that
That's
correct?
correct.
And have you drafted those? Do we know what those?
Staff does not have any conditions of approval to add.
Okay.
I just need clarity on the second option, grant the appeal, because it doesn't say thereby approving the appellant's revised proposal on the screen, which is what you said.
Right, well, I guess the third, on the third option, I mentioned revised because that would be further revised. I guess we are speaking to the appellant's proposal that is sitting on the table
This brand
at
new
this
one.
moment.
So we
So-
would be approving the revised proposal.
Yeah.
Yes.
Okay,
I guess
so
I should have said a further revised proposal.
We would be granting the appeal. We would be overturning the Design Commission's decision to deny the request with conditions of approval or design revisions, and thereby approving a revised proposal. Is that right?
We could
Because
add the,
that's what I've written down.
we could add the date of the proposal
Okay.
to help clarify that.
Great.
So
Good.
if we were to do that, I would think we would have to have a condition of approval about the construction management plan and the mitigation for that. What happens if it turns out when they're doing the pile driving or the foundation that they can't use the auger, that they have to go to pile driving?
Well, I think at that point, they will have their construction management plan in place. They will be doing monitoring because they had done it, if the neighbor so allows them, they will have done a baseline for the adjacent neighbors, and they'll be continuing monitoring those foundations. So my thought would be that they would proceed with care. It'll be a monitored process. So you could add a condition of approval.
Yes, it's like these are fragile, very old houses, and I know we had lots of discussions at council about Central City pile driving and how disruptive that is even to new buildings adjacent to them. So I'd be very concerned if they had to change.
Yeah, you may want to ask the applicant that as well, but
Yeah,
I think that could be a
I
condition.
don't mean to be a stickler, but I've been coached that I'm not allowed for us to bring new items to the table other than the design review issues. So the construction issue, I think it's appropriate if we want to ask them if they happen to come up. I think it's an appropriate question, but it should not necessarily be considered in the case of this particular appeal.
Well, I would actually maybe argue against that, because, I mean, there are approval criteria on respecting adjacent residential neighborhoods and designed to enhance themes in the district.
Well, let's ask
Mayor,
him.
I'm
Let's
gonna-
get him up here. Commissioner Fish.
Yeah, I want to foreshadow, I'm ready to, today I'm prepared to cast a vote on this issue, and I think it would be helpful to have the appellant tell us, answer any questions council has to see if we're all in accord as a way of resolving that issue.
So, legal counsel, just to be clear, so we still have to stick to the process, which is the appellant gets some amount of time. Why don't we do this? Why don't we give the appellant as much time as they need to make their case, and then we don't charge them time to ask our questions and have our deliberations? Then we'll give opposing parties the same amount of time. Does that seem like a fair
Yes, as long as it's the
proposal?
same amount of time. It might be good to set some limits on how long the applicant gets to speak so that when all of those in opposition start speaking, they're not also speaking the same amount of time. I think last time we had 10 minutes and then 10, 10, 10, and it got long, so
Well,
that's up to you. That's your
I
decision.
will evoke the great leadership of former Mayor Vera Katz when she was Speaker of the House. Do you want to hear yourself talk, or do you want your project? Is maybe the operative word.
Did our council just say 10, 10, 10? I think.
I don't even know what that is.
I think we're moving up your vacation schedule.
All right, so any further questions for staff before we bring up the appellant?
I just actually
Sorry.
wanted to answer a little bit more to
Yeah,
your
please.
discussion about the base. So in terms of the construction management plan, I think that can't be the basis of the decision. However, as policymakers, you can speak to that and talk to the applicant about that.
Great,
So I
thank
think
you.
that's, if that further guidance. All right.
Thank you.
All right, the appellant. So let's try to stay within 5-ish minutes, just so we all go home tonight. But we want to give
We
you
have-
full reign to make your case.
Thank you, Mr. Mayor. We have 3 people to testify, and our hope was to stay under 10 minutes.
Perfect.
For your record, my name is Tim Ramus. I'm legal counsel for the project. With me also is Landon Crowell, who's the project owner, Jerry Waters, who leads our design team. When we last met, we were left with 3 fundamental questions to respond to, and what our objective here today is to let you know where we are on those. The first was, can you do something to soften the design effect of this project on the properties to the north? And the answer to that is yes, and Jerry will go through the changes in more detail, but they are along the lines that Grace described. Essentially, this project has moved from being a 0 lot line project to one that has setbacks. And that distinction has allowed us to address things like maintenance questions and the construction issue and those things that were being raised. The setbacks have been added so that it allows us also to add windows and create some separation to the properties next door, including being able to keep the historic 8-foot separation that is typical in this neighborhood between structures. So we're able to accomplish that. Second question is, are you going to be able to build and maintain this building without encroachment? And the answer to that is yes, and we've submitted a plan in the record where Vic Construction describes how that will be done. They have been constructing 0 lot line and close to lot line buildings since 1947 in the city, and so we think they are a good, credible source when it comes to designing how to do it. The third question is, can you soften the construction impact, the construction period impact on surrounding properties? And the answer to that also is yes. While we might not be able to be conditioned involuntarily to address some of these things, we volunteer to have the construction plan attached as a condition. So you need not worry about the question of authority, but we volunteer that. Essentially, there are 2 key aspects of it. First, there will not be any pile driving at all. There'll be no digging of a basement, so there's no issue of shoring, safety, and collapse. There will be no driving of piles because we'll use an auger system where we'll drill a hole in the ground and inject concrete into that. And if you want more detail on that, we have someone who can describe that process. But there will be no pile driving, so that's a non-issue. If we tried to do it, it would violate the construction management plan and therefore be a violation of our conditions, and we couldn't do it. Also, Mr. Crowell agreed that even though he doesn't have a settlement agreement with our neighbor, Ms. Sturgis, he will volunteer to extend to her the same protections that are being extended to our neighbor to the south, which were negotiated on their behalf by the Schwabe law firm. That would include a process by which no construction would take place until there was a survey done of that property to the north, including a qualified structural engineer examining the foundation and making specific recommendations as to the construction techniques that would have to be used in order to protect the properties to the north. And the contractor will be required contractually to honor those recommendations from the structural engineer. So that's the process that we'll use for protection. I'll stop there and turn it over to the design folks. Thank you.
Good afternoon. I think Grace did a fairly nice job of describing where we've come to since our initial hearing before you. The big one being the addition of setbacks on the Ankeny, on the 12th Street property side, where we've included a 4-foot setback on the south in response to some neighborhood meetings and direct negotiation with the neighbors on the south. On the north, we've extended a 3-foot setback for over 50% of the building portion that you can see here. This piece back here is actually a void, so there's really only building from here to here. That portion, we're giving an 18-inch or 1'6" setback, and we believe that we can maintain that. And then along the rear property of the Sturgis, rear property line of the Sturgis property, or our east property line on the Ankeny Street side, we've added an additional 3-foot setback along their property there, again, to be able to construct and maintain this building and not cause any interference with the Sturgis property. Here are some massing views showing some of the changes that we've made since that time. I think Grace started with those, but so the massing on that north side of the 12th Street has increased in its differentiation with volume and mass. The height has come down by more than 5 feet, and we've added additional setbacks and notches to increase the windows, which was a comment that both Design Commission and the neighbors had. So here's a view of where we were when we sort of finished up with Design Commission on the left and the changes that have been made to date. The Ankeny Street side, other than material changes, that has really not been an issue. But here's the 12th Street side showing going back to wood siding and the addition of windows, the additional setback, and the massing changes to articulate that north facade and not have such a blank sheer facade.
Could you please point to the wood siding, just so I'm clear
So
on
the
where
wood
that is?
siding will be from level 3 to ground.
Okay.
So it's wood on the first 3 levels, and then when it steps back, then that's when we transfer to a zinc siding. So the zinc is a 100-year material, long-lasting. It's used on buildings throughout Europe that are very old. And our wood siding, we're using a factory-applied semi-transparent stain that when it's factory applied with a primer and 2 coats, we can get an industry 25-year warranty on. So we feel that we're providing both the sort of residential feel that has been asked for, and at the same time, the durability and maintenance issues are really being put aside.
How much more is the setback on the top structure?
The top is 3 feet from the north property line.
From here, from Ankeny?
Yeah, so this is,
Yeah,
this,
there.
this piece is consistently 3 feet from the property line.
Yeah. But that structure on top of the square is set back where there's a tree in the foreground. How far back is that?
Oh, how far is that? Oh, I don't know if I know a dimension off the top of my head, but it's at least 8 feet, I would guess,
So
because
there's
there's a balcony space
There's a
up there.
courtyard space up there?
Yes.
Okay. Thank you.
And so I think that pretty much concludes the bulk of the changes we've made in an effort to meet the suggestions and the negotiated requirements.
Very good.
No, this is not our decision point on this basis, but when you've gone essentially through a design process by committee where you've heard lots of voices and you're making changes responsive to neighbors, I have no standing to say this, but I think the revised building is an improvement over the original building. It's a very handsome building. So I congratulate you for balancing the neighborhood concerns, but also having a building that's quite distinctive.
Well, thank you. I think anytime you spend more time working on something, in theory, it should get better. Although sometimes we worry about death by 1,000 cuts, but. But I also would like to add that in all of this, we have maintained our desire and goal to be a net zero project.
Thank you.
Okay.
Anything else for this panel?
Oh, I have a question to the lawyer. So just so I'm clear, because we've done a lot of work today, and I just want to make sure we have our eye on the prize here. What is your recommendation in terms of the action we take? Sure. And would you wordsmith it for us?
Yes, we are asking for a motion that would approve the appeal based upon, A, the revised design which you have reviewed today, and B, the addition of a condition requiring compliance with the construction management plan.
I think I can follow that, thank you.
Commissioner Fritz?
What does happen if you get in there and it turns out you can't use the auger, you have to do with pile driving?
Because we're conditioned at that point to do the auger, if we wanted to change the construction technique, we'd have to come back and apply for an amendment of conditions and go back through the hearing process.
Thank you.
I might mention, too, that the structural engineer has already approved the auger cast pile. In fact, we had originally started with GeoPiers because it would have saved us $30,000, and rather than do that, we're spending $30,000 more to address the neighbor concerns. And I might also mention that we're looking for innovation wherever we can find it, because this is going to be the first prototype. We want to be right all the way across the board, so we're considering modular construction too. So that'll eliminate some of the noise and what have you too. So.
That's an interesting idea. Good. Any further questions for the panel? Great.
Thank you.
Have a seat.
Okay.
We'll be right back.
I would be remiss if I didn't thank the staff for all the work they've performed on this, and also Ms. Sturgis, who, although we haven't reached agreement with, she was very forthright in letting us know our issues so we could at least attempt to address them.
Very good. Thank you. So next up, I don't know if there are other participants who'd like to testify about the new evidence. They don't have to be in opposition. They can be in support of. Is there anybody here who would like to testify in opposition to the revised proposal that's been brought forward? All right, colleagues, that leaves it up to us. Unless legal counsel, am I skipping any part of the process here?
You're doing great.
Commissioner Fritz, when I asked the attorney to give us his recommendation, did he accurately state the position that you had originally articulated?
Yes.
Would you like to offer that as the resolution?
Well, I suppose I have to, because the code says that an application will be approved if it meets the conditions of approval or if it can be conditioned to meet the conditions of approval. I have to say I'm really reluctant to reward a process that's had 5 hearings at the Design Commission, 5 hearings before us. I don't think your Bureau has had compensation for at every step of the way. So I hope that when future applications go to the Design Commission that things will get resolved there before 5 times, because as I say, that this is not the best use of the council's time, it's not the best use of your time either. And certainly I appreciate the neighbours having been responded to at the end. It would have been better to have responded to them at the beginning. But that said, I move that we approve the appeal with the revised conditions of approval.
Second.
So we have a motion from Commissioner Fritz, a second from Commissioner Fish. Legal counsel is giving the head nod. Any further discussion on this matter? Call the roll.
Yeah, I mean, you said revised condition of approval. Based upon the revised design and the condition requiring construction, the construction management plan.
Correct.
Okay.
And you'll have to come back with revised findings, won't you?
Yes, it's a tentative decision, and then we'll come back for revised findings based on, the applicant needs to prepare the revised findings. I believe his attorney has already started to do so. So I'm not sure when a good date to come back is. Our office will want to review them as well.
Do we have to specify a time certain today, or can we hold off on that and just notice?
We should have a date to come back.
Carla's got the book.
You want to go 2 weeks out, or how long do you think you need for to do the findings?
I can have a draft to staff by the end of this week.
Okay, so, we're kind of pressed for time here.
Are we under a clock? Okay, so I see a nod. So you want to bring it back the 24th? We just need 5 minutes?
You just put the police item to the 24th, and then the Portland.
What time is the police item?
2 o'clock, and
Let's
then
put this at 2 as well. This is 5 minutes.
we can't do two time certains. We've got like a 2:05 or.
How about we
Why
make
can't we do it
this?
in the morning?
Huh?
Why can't we do it in the morning? It's only going to be 5 minutes for the vote.
I'm going to be here in the afternoon. I don't know if you know, I want to make sure you have a full complement. Could we make this at 2 o'clock in the afternoon and move the police to 2:05 in the afternoon?
That'd be up to
Mayor?
you. I don't.
Just so all we're doing is voting on it.
This is a weighty
Renotice.
decision.
Yeah, I would hate to have you have to renotice the police decision by moving it 5 minutes
We're just
out.
going to inconvenience people 5 minutes.
Yeah.
They're going to come at 5, we're going to take it up at 2:05. Mayor, you have that discretion.
I don't have a problem with it. I mean, legally, do you have renoticing it means sending out another email and
That's fine.
hitting send. I'm okay
And
with
is
that.
you're just going to be here in the afternoon, you won't be here in the morning, is that what the concern?
If you want me in here in the morning, you'll have to take it up with my wife.
Well, we
I will be gone
You'll be
next
gone.
week.
That is,
Okay,
it's,
that's good.
no, this,
No, it's the week after.
Oh, okay,
So,
I will be back.
it's my vacation, but
Unless
I'm
I-
going
If
to
the
come
three
back
of
the
us are going,
afternoon.
if the three of us are going to be
Stay
here
Wednesday.
in the morning of the 24th, we could do it
And
then.
you just let us design your building. This is great.
Yeah, no,
Sorry,
really.
go ahead.
I am very sorry. I am getting a message from our Chief Deputy Land Use Attorney that we would like at least 3 weeks so that our office can do an adequate review.
Good.
So pushing it out one more week, and that still leaves us within adequate time to satisfy any statutory timelines.
Great.
Follow me?
Which have been blown anyway.
Okay.
Second, third, is it?
The
Second?
31st. It would be Thursday, the 31st at 3 PM is available, and only Commissioner Saltzman is out.
Let's do it. Does that work with the applicant? Okay. There's usually very little drama when it comes back with the findings, but just in case.
That's my birthday, by the way. I prefer ice cream, in case anybody's wondering. So are we good?
I think so. Yes, Thursday, the 31st at 3 PM, time certain.
Very good. All right. Call the roll.
Udaly.
I think this was the first land use appeals hearing that I got to sit in on. It feels like that was eons ago, and as fascinating as it's been, I'm really glad it's almost concluded. I don't think either side got everything they want, and maybe that's, the best we can hope for in this process. I just appreciate everybody's input and your willingness to address our concerns. Aye.
Fritz?
Well, I made my comments before, but I'll stress again, thank you, Grace Jeffrey and Tim Herron, for all the work you've been doing. Thanks to the Design Commission, who obviously tried to do their best to get it to an approvable form. And I hope we never again have applications that take 10 hearings in order to get it right. Aye.
Fish?
Well, first of all, I want to say that I think the final result is pretty terrific. And if this is built to these specifications, I think it's going to be an asset to the community. And I love the fact that you're setting the bar so high in energy efficiency. This process is inherently messy, as is democracy. But the goal is to get to the finish line and to bring as many people along with us as possible. And I appreciate the fact that everybody is stretched. I too would prefer that these things in a perfect world come to us from the design. If there is an appeal, that there be narrow issues, and that the bulk of the work be done at the administrative level, because that's how the system was envisioned. But there is this opportunity to appeal to this body. I will say, though, that given the amount of cranes in the air and applications pending before the Bureau of Development Services, it's probably unsustainable for us to be spending this much time. And just as I'm sure the applicant in this case is looking forward to not returning to City Hall in the near future and focusing on his business. But that said, we are all charged with getting to result that the code anticipates, and I think this is a pretty terrific project, and I thank everyone for guiding us to this point, and I'm pleased to vote aye.
Wheeler.
I want to thank the applicant, and I want to thank the neighbors who spent a considerable amount of time going back and forth on this, and I think coming to a very solid and amicable resolution. It seems like we've made slow progress at every one of these 4 hearings, but when you compare what has been, what is now in the final proposal, until then, the appeal is granted. Thank you,
We
everybody.
take a 2-minute break as we get
It's
settled?
3:30 times certain.
Oh, excuse me, okay, good.
Yes, we have to take a break until 3:30 because the next hearing cannot start until 3:30. So we will be in recess until that time.
LDSEN.
Colleagues, this is a hearing that's been continued from June 22nd. The record is closed. And just to be clear, I have been made clear by legal counsel that if we choose to do other than deliberate amongst ourselves, or if we bring staff back up for further discussions, that could trigger reopening the record. So I just want you to be aware of that fact. Council is here today to deliberate and to adopt a tentative decision. For the record, I was not here for the prior hearing. However, I've reviewed the entire record, and I will be participating in today's hearing.
Do we need to do ex parte contracts again or not?
I don't believe why don't I ask just to
attorney
be on
saying
the...
yes?
Yes.
Yes,
So,
okay.
And Mr. Mayor, I'd also ask, because you were not at the.
Yeah, okay, I'm sorry, thank you. Because I was not at the prior hearing, I also want to take the opportunity to declare that I have no conflicts of interest in this matter. I do want to ask if any members of the council have any ex parte contacts to declare or information gathered outside of this hearing to disclose, including any contact that might have occurred since the last hearing. Does anybody have any ex parte contacts?
I just want to declare, as I stated previously, I have met with members of the Hayhurst Neighborhood Association, or Hayhurst Neighborhood, I should say, about this development prior to the appeal being filed by the neighborhood. Subsequently, Matt Grum and my staff has met and spoken with neighbors, as well as the attorney, Mike Robinson, for the developer. And I have been briefed on those conversations. And in addition, I did see a KATU story on the news on July 12th about this proposal as it affects safe routes to schools.
Does anyone present in the council chamber wish to ask commissioners?
I need to put something in the record as well. Thank you. I need to say that Claire Adamsick on my staff has talked with neighbors and has briefed me on those conversations.
Does anybody in the council chamber wish to ask Commissioner Saltzman about any ex parte contacts or information he has disclosed? Come on up. State your name for the record, please.
For the record, I'm Peggy Hennessy here on behalf of the Hayhurst Association, Neighborhood Association, and
Go ahead and grab a seat.
Yeah.
would like to ask what the applicant's attorney's comments to your staff were.
I'd have to ask my staff that.
Okay, you said your staff had briefed you on what he had said to them, and we were just curious what
Yeah,
that
so
was.
I think generally it was all in the context of trying to find, some sort of a compromise here. I was interested, I think as I stated at the last hearing, about the notion of a cul-de-sac. So I'm sure the applicant's attorney probably provided some feedback on that idea. And then also the agreed upon condition of approval that both sides have agreed to that I want to offer as an amendment today.
Okay, thank
Probably
you.
about those deals.
Thank you.
Very good. Would anybody who is in the chamber today like to ask Commissioner Fritz about her contacts or information that she has disclosed? I do not see anyone. Have any members of the council made any visits to the site involved in this matter? Since the hearing on June 22nd, the record was held open. I would like to note that the entire record is here and has been placed physically before us. So at this point, colleagues, we are ready to deliberate. We can tentatively deny the appeal and uphold the decision of the hearings officer and return with revised findings. We can tentatively deny the appeal and uphold the decision of the hearings officer with additional conditional approval. We could return with revised findings, or we could tentatively grant the appeal, overturn the decisions of the hearing officer, and return with revised findings.
So Mayor, as I indicated a minute ago, I do have an amendment I would like to offer to the
Please.
decision. And this was agreed upon by both the applicant and the appellant. And it reads as follows. the applicant and the Hayhurst Neighborhood Association shall agree upon a plan for barricading the extension of Southwest Pendleton Street, and such agreement shall not be unreasonably withheld, so that the extension may be used only by pedestrians, bicyclists, and emergency vehicles, and such plan shall be approved by the Portland Bureau of Transportation prior to the approval of final plans for the subdivision's construction and any ground disturbing activities except for site testing. So I would offer that as a condition to the approval.
So that has been offered up. Is there a second to the amendment? For purposes of discussion, I'll offer a second.
So, yeah, I believe this is an effort that will protect what I do think is a safe route to school along Southwest 48th, I believe the street is, and also prevent traffic infiltration from Southwest Cameron through to Southwest Pendleton to Southwest 45th or other points. I think it does provide for pedestrian bicycle access and emergency vehicle access, and I think we have done this type of situation elsewhere in our city.
Commissioner, could you explain how it could provide access for emergency vehicle and not regular vehicle traffic? I mean, how would that be controlled?
I believe that the Portland Fire and Rescue does have situations where they have access to roads that are otherwise locked by gates. And so I would imagine this would be either gates or bollards or something to that effect that could be removed in an emergency situation.
Okay.
How does that jive with our policy of having connected streets?
Well, I guess it doesn't. I mean, it does, it jives with it in respect, in as much as it does provide pedestrian and bicycle access, but it doesn't jive with respect to vehicular connectivity of streets.
But we have a transportation planning rule that allows a variation from the street connection standards when the topography prevents such connections, but the topography doesn't prevent such connections here.
Well, we have a rule, but I guess I also believe we should be mindful of the individual circumstances of each case that comes before us, and then how those rules apply is up to us to make a decision on. And I guess my coming down on it is this type of a compromise reached by both sides has merit and will, I think, protect the safe routes to school and also allow the development to achieve its objectives as well.
So I'm really concerned about the precedent being set here. I mean, we've had a lot of discussion about the Southeast 148th subdivision where we're requiring a connection against the wishes of the Argay Terrace Neighborhood Association. I see this as, the recommendations from your staff in transportation is to have the connected street.
Right.
Perhaps, Mayor, we should test the amendment.
Well, I was going to ask Commissioner Saltzman if he wanted to revise that or if we should just call the question.
Well, I don't have, I'm taking the language that was presented to us by both sides, so I don't necessarily have an alternative version in mind, so we could call the question if you want.
Since the
Commissioner Fritz.
amendment is new, though, so don't we have to take public testimony on that?
I believe it opens the record back up.
Yeah.
Well, isn't it a condition?
Yeah.
So it's being offered as a condition. If you would like to take public testimony, you would need to reopen the record. This meeting has not been noticed as.
No, my question is, do we have to take?
No.
Okay.
It's a condition.
Okay.
Sorry.
Call the question. Please call the roll.
Saltzman,
Aye.
Udaly,
No.
Fritz,
No.
Fish,
No.
Wheeler.
No. The amendment is not adopted. So I will entertain at this time, colleagues, if people have a preference any of the three options, I'll accept a motion.
Well, as with the previous hearing we just had, that if an application meets the approval criteria, or if it can be conditioned to meet the approval criteria, we are required to approve it. And so I move to deny the appeal and uphold the hearings officer's decision.
Second.
So we have a motion from Commissioner Commissioner Fritz to deny the appeal. Commissioner Fish seconds that. Any further discussion? Call the roll.
Saltzman?
Well, I will oppose this motion. I do believe I've been convinced by the hearing and also the record that there are legitimate concerns about people's getting to and from Hayhurst School, legitimate concerns about traffic infiltration into the neighborhood, and so I vote to uphold the appeal. I'm voting.
So you're voting no?
No.
I'm voting no.
No
Yeah,
on
okay.
denying the
Voting no.
appeal.
I'm voting no. Okay, I always get that confused.
To be clear, we are the motion is to deny the appeal.
Okay, I'm voting no.
Commissioner Saltzman is voting no.
Udaley?
Well, I sympathize with the neighborhood. I feel like our rules and codes are very clear and that the developer is in compliance with them. And our bureaus have also seemingly supported that, so aye.
Fritz?
Yeah, the rules don't say, is it the best that can be done? I mean, certainly if I was starting over on this, and possibly even if the applicant was starting over on this, it would be different compared with after having the neighbourhood input. But the rules don't say, is it the best that can possibly be done? It says what the standards are, and it's important for people to be able to rely on those standards.
The rules allow for discretion.
Excuse me, please, no interruptions of deliberations.
The rules are such that reasonable people can and do disagree, and that's what's the essence of a land use decision, is that's why we have public hearings, that's why we have approval bodies, to make a choice. I will have to say that the piece of this application that really disturbs me is the unprotected seeps and springs, which I think will be a problem for the house that's very closest to them and may indeed be a problem for the watershed. I had thought in the subdivision process that I was involved in on the Planning Commission that we had fixed that problem, and apparently we have not. So I hope that in a future Bureau of Planning and Sustainability code effort will get changed. I would say to neighbours, when I was a land use chair of a neighbourhood association, when I didn't get what I wanted, at the very least I tried to fix the code so that things didn't happen again that way. And that's what we have to do. If the outcome is not what you want, then the rules perhaps haven't been set up the way we want them, and please continue to participate in the planning processes. Aye.
Fish?
I thought in this case, the appellant and the neighborhood association did a excellent job putting forth its case, and well represented and made a good record. I'm persuaded, though, that based on the code and the record before us, that the proper outcome here is an aye vote, so I vote aye.
Wheeler?
So I have a like mind to Commissioner Fritz in terms of the rules being explicitly clear so that we are agnostic in terms of the players that are involved. I appreciate what Commissioner Saltzman is raising as an issue, and I think it is a legitimate safety issue, and I know that PBOT and the applicant are prepared to install mitigation strategies, including speed bumps and the like, if necessary, and that's something obviously we want to continue to work with the neighborhood on. I vote aye. The appeal is denied 4-1.
And just to be clear, that was a tentative
Vote,
decision.
thank you.
so
And the
yes, let's-
final decision will be on, we'll go to the calendar. Carla, sorry.
How long do we need to come back?
So that applicant will need to prepare revised findings and then prepare them for staff in our office to review.
Are we on the clock on this?
No, we have time.
We have a very busy August, so we push this out sometime in September?
Okay, so early September. Is there
No, we've Boy.
It should be a 5-minute item.
Let's say 11 a.m. on the 6th, Wednesday, the 6th. That's the first week in September.
Which, for those of you who may be coming, probably means closer to 12, but it's scheduled for 11.
September 6th at 11 a.m., time certain.
September 6th, 11 a.m., time certain, Portland City Hall Chamber. Will be the final vote on that. We are therefore adjourned until tomorrow, Thursday, August 10th at 2 p.m. Thank you.